This is Swamrai Chaudhary. So today we'll be discussing about guidelines for arrest. So this particular video will be helpful for the law students, judiciary aspirants, and also for the common people. So why the guidelines for arrest are important? So before the Supreme Court started to intervene into these matters, there was too much arbitrary use of power by the police officers. So they would take anyone, they would torture anyone, and they would leave them. So the guidelines for arrest were very much needed. So today we'll be discussing about some case laws where the guidelines for arrest has been given. So first of all, we all know that the section 41 to 60A of CRPC lays down the provisions relating to arrest of persons. So in the recent case of Social Action Forum for MANAV ADHIKAR versus Union of India 2018 10 SCC 443, few guidelines were laid down. So this is a very important case, especially if you are preparing for judicial services. So some of the guidelines that were laid down are: law of arrest is one of balancing individual rights, liberties and privileges on one hand and individual duties, obligations and responsibilities on other hand. No arrest can be made in a routine manner on a mere allegation of commission of offence made against a person. So in this case, the Supreme Court said that if only a mere allegation is made, the arrest should not be made. The arrest should be made only after proper investigation and all. A person accused of offence punishable with imprisonment for a term which may be less than 7 years or which may extend to 7 years with or without fine cannot be arrested by the police unless conditions mentioned in section 41 1B have been fulfilled. So I would suggest that if you are looking at this video, you should open your BEHAR Acts to see what the provision says. So another important case in this regard where the guidelines for arrest was made was Joginder Kumar's case. So Joginder Kumar's case is a 1994 case, and here some guidelines were laid down. Some of these guidelines are: an arrested person in custody is entitled to have one friend, relative or other person. He shall be informed of his right by the police officer making arrest. An entry shall be made in the diary as to who was informed about his arrest. Then moving on to the landmark judgment in this regard, that is D.K. Basu versus State of West Bengal, which is a 1997 case, and the citation is 1997 6 SC 642. So here some 10 to 12 guidelines were given. They are: police personnel making arrest, holding interrogation should bear an accurate and clear identification mark with their designation. Police officer making arrest to prepare memo of arrest which is to be attested by at least one witness. So police officer should prepare a memo of arrest and it is to be attested by at least one witness. Arrested person is entitled to have his friend or relative to be informed of his arrest. Arrested person is to be made aware of his right to have someone being informed of his arrest. Arrested person must be examined at time of arrest, and every minor and major injury must be recorded. So arrested person to be made subject to medical examination by a trained doctor. So a trained doctor should examine him every 48 hours. Copies of all documents including memo of arrest should be sent to a magistrate for record. Arrested person to be produced before magistrate within 24 hours. So within 24 hours the arrested person should be produced before a magistrate. Arrested person should be permitted to meet with his lawyer during interrogation. The police control room should be provided at every district and state headquarters. D.K. Basu versus State of West Bengal case laid down the following guidelines, and they were later adopted by the Parliament as well in the 2009 amendment to the CRPC. So prior to 2009 amendment of CRPC, section 41 empowered the police officers to arrest any person without warrant if he was committing any cognizable offense in his presence or against whom a reasonable complaint or credible information was received to that effect. Thus, mere fact that the offense was cognizable gave the police officers ample powers to curtail the liberty of any person and arrest him. So, DK Vasu versus State of West Bengal made way for the 2009 amendment. Another important case relating to guidelines for arrest is ARNESH Kumar versus State of Bihar. The citation is 2014 8 SCC 273. So following guidelines were laid down in this case. No arrest is to be made merely because the offense is non-bailable and cognizable. No arrest is to be made without reasonable satisfaction as to the genuineness of allegation. Police officer has to forward the checklist furnishing the reasons for arrest to the magistrate who shall authorize detention as per section 167 of CRPC after recording satisfaction. So a police officer has to satisfy himself that the allegation made against the person are genuine, then only he can arrest the person. Then he will write down the reasons for the arrest and send it to the magistrate. Then magistrate, if the magistrate is satisfied that the allegations are genuine, then only he will authorize the detention under section 167 of CRPC. If the police officer is defying any of the directions, then it will attract departmental action and can also attract contempt of court. Hope you like the video. So this topic is very much helpful for all the students, and I will be making more videos in the upcoming days. Stay tuned.